The Clearview AI database is still scraping your face right now, and the Department of Justice can't stop it. 30 billion images, pulled without consent, running on servers the government has inspected and walked away from. Tonight I'm going to show you the legal structure that makes this database untouchable, and the document that proves the people meant to protect you already lost. Clearview markets itself as a law enforcement tool. You upload a photo, a grainy ATM still, a doorbell camera frame, and it searches a 30 billion image index and returns a match in seconds. Name, employer, social accounts, address history. The FBI uses it, ICE uses it. Over 600 law enforcement agencies across 41 states subscribe. The official justification is simple. It solves crimes. It identifies missing children. It flags suspects before they disappear. That's the product Clearview sold to the federal government, and Washington bought it, because the pitch was too useful to question, and because questioning it meant admitting they'd already been using it for years. What Clearview didn't disclose is that the scraper never turns off. While law enforcement queries run through a licensed portal, the data collection operation runs in parallel, persistent, automated, and continuous. Clearview operates a distributed crawler network that revisits indexed domains on a rolling cycle. Every time you update your profile photo, the system flags the change, rescrapes the image, and attaches it to your existing record. Every time your face appears in a news article, a court filing posted online, a school directory left unsecured, the crawler finds it, indexes it, and it becomes a new data point in your biometric profile. The face you had at 19 is in there. The face you have now is in there, and the face you'll have next month will be in there within 72 hours. This is not a historical archive. It is a live feed, and it has never been turned off. The Federal Trade Commission opened a formal investigation in 2021. Illinois filed suit under the Biometric Information Privacy Act, the strongest facial recognition law in the country. Canada's Privacy Commissioner issued a binding order demanding deletion of every Canadian face in the database. Clearview's response to Canada: we'll stop collecting new images, but the existing records stay. To Illinois: we'll stop selling to non-law enforcement clients in your state. The database stays. The FTC produced a consent order in 2023 barring Clearview from selling data to private companies. The scraping itself was never addressed. The Department of Justice reviewed referrals and declined to bring criminal charges. Every oversight body that investigated walked away with a partial settlement. The database kept growing, and it's still running. Here's the part nobody reported. Clearview's legal team built the entire data operation around a single constitutional argument. The First Amendment protects the right to collect, analyze, and index publicly available information. When you post a photo publicly, the argument goes, you've entered it into the public record. Clearview is simply reading the public record at scale. Courts in 4 jurisdictions have partially accepted this framing. The ACLU settlement in Illinois required Clearview to stop selling to most private entities, but explicitly left law enforcement access untouched and the crawlers running. And because Clearview doesn't store the original scraped images, only the biometric faceprint derived from them, it sidesteps most state biometric privacy laws entirely. A faceprint is the numerical encoding of your facial geometry, a mathematical representation. Legislatures wrote laws protecting photographs. Clearview stores math. That distinction was not an accident. It was the architecture, engineered before the first lawsuit was filed, before the first congressional hearing, before the FTC opened its investigation. The loophole was built into the product at the design stage, and the government for 3 years wrote regulations about photographs while Clearview quietly stored vectors. The mechanism that makes it unstoppable was never a secret. It was published in their terms of service. Nobody read them. Right now your face exists in a database you never agreed to, feeding a search engine you cannot opt out of, accessible to 600 agencies whose query logs you cannot request under FOIA, because many searches are pre-investigation, before you're a suspect, before there's a case number. A detective in a city you've never visited can upload a photo of someone who looks like you and pull your full linked identity in 4 seconds. No warrant, no probable cause, no notification. The biometric checkpoint exists everywhere your face has ever appeared online. It runs silently in the background against every query that comes in, and every time there's a match, a record of that query joins your file. You don't know who searched for you. You don't know what they found. You don't know what they did with it. So here's the question nobody in Washington will answer on the record. Clearview's investors include former federal officials. Its government contracts have grown every year since the FTC action. The DOJ looked and walked. 600 agencies renewed their subscriptions. Who exactly is supposed to shut this down, and why does every authority that investigates it come back with a reason they can't? Your face is already in there. The only question left is who's searching it right now.